Welcome. I'm Alex Novarese, Editor-in-Chief of Legal Business and the in-house lawyer magazine, and I'm here today to chair a debate on one of the key issues keeping General Counsel awake at night, data security.
So the cases I've done in litigation, Alex, are about the negative incentive which is in the regulatory scheme. So the way the privacy and security regime regulates in the UK right now is actually to punish people for doing the right thing, to be transparent. So I don't actually believe in punishing people for doing the right thing. But a better example of
it, could you just give us a line or two on what you mean?
Yeah, so if you were to do voluntary breach reporting to the Information Commissioner's Office, that is an accelerator to a regulatory penalty or sanction. And that's a negative incentive, because if you are going to be transparent and do the right thing and add to the knowledge of the regulatory office, or add to the knowledge of the economy, or add to the knowledge of society on incidents and problems, if that creates an obvious and direct chain to punishment, some people will say, I will not put my head above the parapet. So there's a negative incentive. So my point is, I think...
So there should be stronger incentives to self-report quickly and either head off or manage liability.
Yeah, indeed, for instance, and you would have very clear regulatory statements to the effect of, where an entity does do the right thing immediately after an incident and fully cooperates, we will not be using our sanctions regime against them, save in a defined set of exceptional circumstances, and most probably for situations where they refuse to remediate after advice or whatever it might be. So I think we've just got to take the negative incentive out. So sacking the IT person all the time for patching is part of a negative incentive. But where I wanted to go is, I think, a different example, which is perhaps one that works better, about roles and responsibilities for getting it right, is if you think about security contracting right now, So this is in the supply chain, so vendor risk management. So your business engages with another business and there is data passing or network connectivity. You would need an appropriate procurement vehicle and contracting vehicle to deal with some of the mitigations around the risks. Now, in that situation, the question is, who should take the responsibility for making sure that the contract is asking the right things? So there's some contracts that are flying around the economy right now that private practice lawyers have seen, that are being created in response to the General Data Protection Regulation. And what that says in the third-party vendor risk management situation, you need more contracts. So more contracts with more clauses, basically. That's what the GDPR says. But when you read the asks, people are asking in contracts for things that will never help them in a security incident, and very arguably would be counterproductive in the security incident. So these contracts...
Give one example, just to give people a flavour.
In the event of an incident, we have the right to send our auditors in on the ground within 24 hours. Now, the last people you want in the middle of a very, very serious incident within 24 hours is an auditor running around. You could take it to an absurdity. It would be, well, why not send the police in, for instance? Now, what is going to happen there is probably disruption to the efficient handling of the incident, potentially a chilling effect on the environment. Think, who's this auditor? I don't want, I better watch my back.
And presumably in that time frame, you'd know next to nothing anyway.
You'd know next to nothing anyway, and it'd get in the way. So what's happened there is the procurement and legal function just does not understand what would benefit them, the incident, their customers, the third party in that space. Now, what would benefit is some transparency, of course. What would benefit is potentially, evidence coming over of an appropriate remediation plan being executed and actioned. That would be beneficial. So why is the contract asking for immediate audit rights? So in that situation, the failure is plainly the failure of the contracting and procurement team to actually ask the question, what benefit do we need to get in that situation? And what, in my point of view, would happen is that they would then go to the security team and say, look, you're the experts on technical incident response. What do we need right now in the 24 hours after our data's gone missing at a vendor?
So contractually, you're saying less is more. Don't put in lots of extraneous things,
I'm saying, yeah, it's posturing, bad contracting, asking for things that are going to be counterintuitive, because the purpose of that contract is to improve instant response. If that's the purpose, then the contractual mechanisms should improve instant response. But people don't know when they're drafting what's going to help and what's not going to help.
And what would be, so I'm going to get to Raj on a completely separate topic in a minute, but just could you give us one example of what you think would be a helpful thing to include?
Well, as I said, rather than we would want auditors in on 24 hours notice, we would want the production of evidence that a pre-agreed instant response plan had been triggered at the right moment in time. That would be more productive. A clause saying, demonstrate that you've triggered the instant response plan that we had sight of in pre-contractual due diligence that we agreed was an appropriate instant response plan. That would be good. Yeah. That would be really good.
And a right of notification, I think, with transparency would be the sorts of things you'd look for. I think that's absolutely right, Stuart, in that when you're in that type of situation, your fundamental objective is actually to fix the problems. And, it's particularly acute when you're dealing with customer data, personal data. Your primary objective, I always think in that scenario, is see the customer right and try and get them back into the position that you would want them to be in. Sure. And in that scenario, coming to your question about who leads, I'm very relaxed about that. I'm not particularly precious. My view is typically security functions have a lot more resource. Yeah. And in that scenario, that is actually what you need. You need people, you need bodies actually to go around and chase things down, ask the right questions. You might need to talk to third parties, exactly as Stuart says. But you want your legal function in the room. So my experience of this is you absolutely have to be involved. But I don't think it's a question of, as it were, who is it critical that it's the General Counsel or the Head of Information Security? The issue is, have you got the right resource, and have you actually developed the right framework up front? So one of the key things that you need to think about is that data breach preparedness.